Thank you. We will now proceed with the division on Amendment 21, and members should cast their votes now. The vote is closed. I call Jenny Gilruth for a point of order.
Presiding Officer, my app did not connect. I would have voted yes.
Thank you, Ms Gilruth. We'll ensure that is recorded. I call Emma Harper for a point of order.
Thank you, Presiding Officer. My app wasn't connecting quick enough. I would have voted yes.
Thank you, Ms Harper. We'll ensure that's recorded. I call Kenneth Gibson for a point of order.
I would have voted yes, Presiding Officer. Thank you.
Thank you, Mr Gibson. The result of the vote on amendment number 21 in the name of Angela Constance is yes 96. There were no votes against. There were 17 abstentions. The amendment is therefore agreed. I call amendment 96 in the name of Sharon Dowie, already debated with amendment 17. Sharon Dowie, to move or not move?
On the basis that it's supported by Victim Support Scotland, I'll move it.
Thank you. The question is that amendment 96 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division, and members should cast their votes now. Vote is closed. The result of the vote on amendment number 96 in the name of Sharon Dowie is yes 40, no 58. There were 17 abstentions. The amendment is therefore not agreed. I call amendment 22 in the name of the Cabinet Secretary, already debated with amendment 6. Cabinet Secretary, to move formally.
Moved.
Thank you. The question is that amendment 22 be agreed to. Are we all agreed? Yes. We are agreed. I call amendment 97 in the name of Sharon Dowie, already debated with amendment 17. Sharon Dowie, to move or not move?
Not moved.
Thank you, Ms Dowie. The amendment is not moved. I call Amendment 23 in the name of the Cabinet Secretary, already debated with Amendment 6. Cabinet Secretary to move formally.
Moved.
Thank you. The question is that Amendment 23 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 24 in the name of the Cabinet Secretary, already debated with Amendment 17. Cabinet Secretary to move formally.
Moved.
Thank you. The question is that Amendment 24 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 98 in the name of Sharon Dowie, already debated with Amendment 17. Sharon Dowie to move or not move?
Not moved.
Thank you, Ms Dowie. The amendment is not moved. I call Amendment 25 in the name of the Cabinet Secretary, already debated with Amendment 6. Cabinet Secretary to move formally.
Moved.
Thank you. The question is that Amendment 25 be agreed to. Are we all agreed? We are agreed. I call Amendment 99 in the name of Sharon Dowie, already debated with Amendment 17. Sharon Dowie to move or not move?
Not moved.
Thank you. I call Amendment 26 in the name of the Cabinet Secretary, already debated with Amendment 6. Cabinet Secretary to move formally.
Moved.
Thank you. The question is that Amendment 26 be agreed to. Are we all agreed? We are agreed. I call Amendment 100 in the name of Sharon Dowie, already debated with Amendment 17. Sharon Dowie to move or not move?
Not moved.
Thank you. I call Amendment 27 in the name of the Cabinet Secretary, already debated with Amendment 6. Cabinet Secretary to move formally.
Moved.
Thank you. The question is that Amendment 27 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 28 in the name of Jamie Green, already debated with Amendment 4. Jamie Green to move or not move?
Moved.
Thank you. The question is that Amendment 28 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 29 in the name of the Cabinet Secretary, already debated with Amendment 6. Cabinet Secretary to move formally.
Moved.
Thank you. The question is that Amendment 29 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 30 in the name of the Cabinet Secretary, already debated with Amendment 6. Cabinet Secretary to move formally.
Moved.
Thank you. And the question is that Amendment 30 be agreed to. Are we all agreed? Yes. We are agreed. We move to Group 5, Research on Child Sexual Exploitation and Abuse. I call Amendment 31 in the name of Liam Kerr, grouped with Amendment 32. Liam Kerr to move Amendment 31 and speak to both amendments in the group.
Very grateful, Presiding Officer. Amendment 31 and the consequential 32 requires the newly constituted Victims Commissioner to conduct an investigation into group-based child sexual exploitation and abuse, also known as grooming gangs, in Scotland. Now, Presiding Officer, we know that grooming gangs operate in Scotland. Just 7 months ago, a Romanian grooming gang was convicted of raping and sexually abusing 10 women in flats across Dundee. Police Scotland conducted an investigation called Operation Kerrar in 2016 into a grooming gang in Glasgow, which reportedly had 44 victims with 55 alleged perpetrators. And we cannot overlook that sexual crimes in Scotland are already at their second highest since 1971. But how prevalent are grooming gangs in Scotland? We just don't know. To be fair, nor did they in England, which is why Baroness Casey was instructed by the Prime Minister to carry out an exercise of the sort precisely envisaged by my Amendment 31 in England in January 2025. So my amendment simply provides for a similar investigation to be undertaken by or on instruction from the new Victims Commissioner. It is an investigation which would build a national picture of what is known about grooming gangs in Scotland. It would identify local and national trends. It would assess the quality of data available, review police understanding of this crime, and assess the demographics of victims and perpetrators. Crucially, It will require recommendations to be made on how to prevent this most vicious, this most heinous of practices from occurring, and to make a recommendation on whether a full public inquiry needs to be commissioned. And it must be done here. Baroness Casey herself said, when asked about Scotland having an inquiry, that I can move from Scotland to England pretty easily, and criminals do. Indeed, they do. Presiding Officer, I'm mindful of the challenges of establishing a new Commissioner, which is why, although Baroness Casey delivered her audit in less than 6 months, I've required in my amendment that the Scottish report be done within 3 years. Presiding Officer, there is currently a worrying lack of information about the true scale of the issue, who the victims are, who is conducting these crimes in Scotland. And I am a firm believer that more data is a good thing, but here we have very little. We cannot bury our heads in the sand while England tackles this. If we were so to do, there is a real risk of Scotland falling behind in dealing with child sexual abuse. I'll take the intervention.
Audrey Nicholl.
The member for giving way, and I think the Chamber would be united in our condemnation of the issues that the member is referring to. But I wonder if the member would agree that rather than this being a role for the Victims Commissioner, this is extremely specialist and complex proposal that he is making, and that any work in Scotland to look at this more closely would need to be done by a more specialist and multi-agency forum.
Liam Kerr.
I think it's a well-made intervention. And I think that the Victims Commissioner that we are bringing in with a blank slate. So actually, the Victims Commissioner can indeed be set up in a way that will facilitate this done appropriately. But as I say, I think it's a valid intervention, because my amendment specifically provides for a Victim Commissioner to appoint someone else to conduct the research on their behalf if they should so wish. They could even appoint Baroness Casey, which I think we would all agree would be an absolute masterstroke. So I'll come back in my closing, please, Mr Whitfield, because, Presiding Officer, at this stage I'd simply like to urge members to support my amendments 31 and 32, which I hereby move, and deliver justice for the victims of grooming gangs.
Thank you, Mr Kerr. I now call the Cabinet Secretary.
Thank you, Presiding Officer. Let me start by saying that the Scottish Government fully recognises the terrible suffering experienced by children who are abused and exploited. And we are all determined to tackle that and share the priority of protecting our children from harm. I know this is a sensitive area and it needs to be treated as such. However, I do not support these amendments, which do not represent the most effective approach to these grave matters. The National Child Sexual Abuse and Exploitation Strategic Group was established in 2024, work that is underway now, not in 3 years' time. It is an expert group of key statutory, third sector, academic and, crucially, service delivery organisations, and is best placed to assess and make recommendations for the additional action to tackle child sexual abuse and exploitation rather than the Victims Commissioner, which I know that the Conservatives had doubts about establishment, which following commencement will need to be recruited and will have a variety of duties to deliver, not least the delivery of a charter that we debated and agreed in Group 1. When it comes to this sensitive and crucial issue, I want to know we have expertise and knowledge on the issue, and the National Child Sexual Abuse and Exploitation Strategic Group is best placed to provide that. The group is already working at pace to strengthen the workforce identification of abuse and improve data collection and information sharing to better understand prevalence and enhance multi-agency coordination to improve our collective response to this abhorrent crime. Police Scotland has advised that there are no current investigations in Scotland involving offences against children and young people which would mirror the investigations described in the UK Government National Audit on Group-Based Child Sexual Exploitation and Abuse conducted by Baroness Casey. However, all members will agree that there is no room for complacency in relation to these hidden and underreported crimes, and Police Scotland is reviewing historical and current cases of this nature. This is essential expert work undertaken by Police Scotland now. Work that Audrey Nicholl, an ex-police officer, alluded to, and who spoke to the expert nature of the detail involved in this work. And this work by Police Scotland will be reported to the strategic group. The strategic group have already considered the implications of Baroness Casey's audit and looking at each recommendation, and will discuss agreed actions, including the findings of Police Scotland's analysis at a meeting next month. Presiding Officer, it should also be noted that stakeholders have already cautioned about the need to ensure that the roles of the Victims and Witness Commissioner and the existing Children and Young People's Commissioner complement one another and are not in competition or create inefficiencies in their important work to scrutinise and uphold children's rights in Scotland. In my view, Amendments 31 and 32, as well as not being the right route to address this issue, would risk unnecessary duplication. I stress that the National Child Sexual Abuse Exploitation and Strategic Group and Police Scotland are active in this area now. And I would not want to represent an inefficient use of resources by creating duplication, resources which could be better directed towards improving prevention and victim support services, an issue which has been repeatedly raised by stakeholders who rightly would prefer focused action rather than more layers of research and review when that is already in place. And I am sure that Liam Kerr will understand these arguments, and I hope realise that his amendments are not the right route and that he will not press the vote this afternoon, and that if he does, I would urge Parliament to reject them.
Thank you, Cabinet Secretary. Thank you, Cabinet Secretary. I call on Liam Kerr to wind up and to press or withdraw Amendment 31.
Yeah, I'm very grateful, Presiding Officer. I'm grateful to the Cabinet Secretary. And let me genuinely first go on record to say I'm grateful for the Cabinet Secretary's approach throughout this process, which has been very collaborative to try and throughout the whole bill, which I appreciate. In dealing with the objections to my amendments, let's start with the First Minister's response to this last week at FMQs, because he claimed that the child sexual abuse inquiry will be sufficient. But, Presiding Officer, he is wrong. That inquiry is vitally important, on that we agree, but it only looks at the issue of child abuse in care. It doesn't look at grooming gangs, and it will only consider events from 1930 to 2014. So Operation Kerrar, that I referred to earlier, took place in 2016, so wouldn't be covered. And neither would the grooming gang convicted in Dundee this year. Presiding Officer, the Cabinet Secretary then today goes on and suggests giving the Victims Commissioner a responsibility to carry out this work wouldn't be the most effective way, she put it, of addressing this issue. And I obviously refer to my earlier response to Audrey Nicholl. The Commissioner can appoint anyone. And I suggested to Audrey Nicholl that that might even be Baroness Casey. And the Cabinet Secretary then argues that some work in this area is already underway. And that is true. And we absolutely support it. But I respond that that does not in any way preclude this investigation from being carried out. Is there really anyone in this chamber who will object to having too much data on this vile crime? And don't... I shall do.
Martin Whitfield.
I'm very grateful to the member for taking an intervention. Mention was made in the rebuttal about the amendment about the role of the Children's Commissioner and indeed the potential conflict between commissioners, and the member himself has just talked about, is it possible to have too much data in relation to this? Is this not a case where these amendments would lead for right-minded thinking, intelligent and expertise people to come together to identify the correct person to do it, but also to identify the sources of data that are not yet available and are clearly not coming forth through the strategic group anytime soon?
Liam Kerr.
I think that's right. I think, first of all, Martin Whitfield's right. There can't ever be too much data on these crimes. And in any event, of course, what I am calling for is a one-off urgent report into a specific area by precisely the Commissioner set up to address victim issues. But Martin Whitfield makes exactly the right point. How can it possibly be that extra collaboration between a Victims Commissioner, a Children's Commissioner and anyone else who has expertise in this, just like Audrey Nicholl rightly pointed out, how is that a bad thing? It's absolutely a good thing, and that is a persuasive argument why you should vote for it today. I will do.
Cabinet Secretary.
Presiding Officer, I'd like to put to Mr Kerr that it is important that we get the right type of data, and that, of course, work is currently underway. But I wonder if Mr Kerr is aware of the work led by Professor Alexis Jay, who was the chair of an independent inquiry into child sexual abuse in England and Wales, who is currently also sitting on our national strategic group, who shares my view and has put on the record and stated to the media that she does not support further inquiries on child sexual abuse and exploitation, given the significant time and resource already spent in the review she led, the Casey audit and indeed other reviews. And she says it's now time that people should just get on with it. And I contend that that is what the Scottish Government is doing right here, right now. We're getting on with the work that we need to do to protect children.
Liam Kerr.
I'm grateful to the Cabinet Secretary, and she's put that on the record, but the Cabinet Secretary will presumably agree with me that there is a terrifying lack of information about the true scale of this issue, who the victims are, who is conducting these crimes in Scotland. And we are lagging behind England on this issue. And the Cabinet Secretary puts to me the point about time and resources, but I put back to the Cabinet Secretary that Baroness Casey delivered her verdict on the matters my amendment covered in a mere 6 months. The Scottish Child Sexual Abuse Inquiry commenced in 2015 and it's still to report. This is absolutely the amendment we need to get action now, which the Cabinet Secretary rightly is demanding. Presiding Officer, we must not bury our heads in the sand on this vicious and pernicious practice of child sexual abuse. The Cabinet Secretary was right when she said there is no room for complacency. She's absolutely spot on that. This is not and must not be an issue of party politics. I'm not suggesting it is. I respect the Cabinet Secretary too much. But I do want to point out that the Scottish Labour MP Joni Reid has called for a grooming gangs inquiry in Scotland, and she and Labour are absolutely right to do so. My amendment mirrors what the UK Labour government has rightly and correctly done in England. Colleagues, I'm giving the Parliament the opportunity to do the right thing here and deliver justice for the victims of grooming gangs and do all that we can to prevent the victims of the future. Do not let them down. Vote for my amendments 31 and 32, which I hereby press.
Thank you, Mr Kerr. The question is that Amendment 31 be agreed to. Are we all agreed? Yes. The Parliament is not agreed, and there will be a division. The vote is now closed. Point of order, Pauline McNeill.
Thank you. Technical problems. I would have voted yes.
Thank you, Ms McNeill. Your vote will be recorded. Point of order, Ros McCall.
Sorry, Presiding Officer. My apologies, Presiding Officer. My vote hasn't registered. I would have voted yes.
Thank you, Ms McCall. Your vote will be recorded. Thank you. The result of the vote on amendment number 31 in the name of Liam Kerr is yes 51, no 62. There were no abstentions. The amendment is therefore not agreed. I call amendment 32 in the name of Liam Kerr, already debated with amendment 31. Liam Kerr to move or not move?
Not moved.
Not moved. I now call amendments 33, 34, 35, 36, 60, 61 and 37, all in the name of the Cabinet Secretary and all previously debated. I invite the Cabinet Secretary to move amendments 33 to 36, 60, 61 and 37 en bloc.
Moved en bloc.
Thank you, Cabinet Secretary. Does any member object to a single question being put on amendments 33 to 36, 60, 61 and 37? No member objects. I now call amendments 33. The question is that amendments 33 to 36, 60, 61 and 37 are agreed to. Are we all agreed? Yes. The Parliament is agreed. We now turn to Group 6, Conduct of Fatal Accident Inquiries. I call Amendment 62 in the name of the Cabinet Secretary in a group on its own. And I call the Cabinet Secretary to move and to speak to Amendment 62.
Presiding Officer, Amendment 62 relates to Part 2 of the Bill, which already makes provision to ensure the courts can set rules on trauma-informed practice for both criminal and civil proceedings. Amendment 62 makes equivalent provision for fatal accident inquiries. It adds trauma-informed practice to the list of matters on which the Court of Session can regulate the practice and procedure for inquiry proceedings. This makes explicit that the Court can set rules designed to ensure that inquiries into fatal accidents and sudden deaths are conducted in a trauma-informed way, and I move Amendment 62.
Thank you, Cabinet Secretary. I note that no other member wishes to speak, and therefore I would ask the Cabinet Secretary whether she wishes to add anything by way of wind-up.
No, thank you.
Thank you, Cabinet Secretary. The question is that Amendment 62 be agreed to. Are we all agreed? Yes. The Parliament is agreed. I now call Group 7, Plea Agreements and Prosecution Decisions. I call Amendment 38 in the name of Russell Finlay, grouped with Amendments 63, 102, 64, 65 and 101. And I call on Russell Finlay to move Amendment 38 and to speak to all amendments in the group. Mr Finlay.
Thank you, Presiding Officer. I've got 3 amendments in this group, numbers 38, 63, 102, and they relate to plea deals in solemn cases specifically. At stage 2, I attempted to bring in some amendments in relation to summary cases, but listened to the Cabinet Secretary's warning about this potentially adding to court delays, so withdrew these. And it's perhaps interesting to note that the ratio of summary to solemn proceedings in court is approximately 6 to 1, in that there are far more summary cases than there are solemn. Now, first up, I should say there's absolutely nothing wrong with plea deals. They have been used for years. They've been used very effectively by prosecutors in the conduct of their business. They can spare victims and witnesses from giving testimony. They can save the courts time and money, and they can incentivise early guilty pleas for the benefit of everyone involved. But far too often these are taken in secret, and there have been some very concerning decisions made. There was one particular case in which it took 4 years for a serial domestic abuser to be found guilty after using every dirty trick in the book to evade justice. And having done so, he was still offered a very favourable plea deal that saw some charges dropped altogether, despite an abundance of evidence, and other charges diluted to remove the worst elements of them. And this is commonplace. It's happening in courts across Scotland today and every single week. Another case that springs to mind is that of Liz Shanks, who has campaigned on plea deal transparency ever since her own case of domestic violence went through the courts, and she discovered only after the event that a deal had been struck, again favouring the accused, who was able to see certain charges dropped despite an abundance of, in this case, CCTV evidence against them. In both those cases and in many others, the victims only found out there had even been plea deals because there happened to be journalists in court. But these are happening, as I said at the outset, every single day of the week. Now, I'd like to start with amendment number 38. Now, the Justice Secretary, after some discussion prior to recess, I'm grateful to her for giving me this as a handout amendment. And what this proposes to do in solemn cases is gives victims the right to opt in to receive information about plea deals. The Scottish Government says this approach is trauma-informed. It's a phrase the Cabinet Secretary has used today already. It's a phrase that I still don't understand what it actually means. But given my point about this particular approach, is, and one I disagree with, or rather I think could be improved upon, is that victims are entitled to know the outcome of their case, whether it be a conviction or an acquittal. So why on earth would sharing the details of a plea deal somehow cause further trauma? Surely they're entitled to this basic level of transparency. I think 38 almost gets there, but it perhaps is at risk of giving an illusion of transparency and perhaps could actually make things worse for victims. And the reason I say that is because the Lord Advocate told me in a meeting to discuss this that all victims are already told about deals, even though we know that does not routinely happen from the abundance of evidence in the public domain. So if it should happen, but it doesn't already, how would Amendment 38 actually change that? The fundamental problem with 38 is that how would a victim know that they have the right to opt in? And the short answer to that is they just wouldn't know. And if you look at some of the opt-in models that have been used in the justice system in recent years, the mass release of prisoners, only something like 2 or 3% of people opted in to find out whether the person that had caused them harm had been set free prematurely. So we know that opt-in doesn't work, which is why we need amendments 63 or indeed 102. Now, 63 is my preferred option. It would mean that in solemn cases, victims would all be told of plea deals, and this amounts to basic transparency. It's simple common sense. Now, Amendment 102 is a bit of a halfway house between the Scottish Government's opt-in model and my full disclosure model, and that would mean that victims would have to opt out of being told about plea deals. Now, I still have reservations about any system that is reliant on Crown Office communication, given the strains that they are under, which is why I think option 63 is by far and away the best option. I've yet to meet a victim in all the decades that I've been working with victims in journalism and in politics who have said that they want less information about their case, which is what option 38, the government handout option, effectively amounts to. Scottish Women's Aid support all three of these amendments. Scottish Women's Aid supports option 102, and Victim Support Scotland support all three of these. And I'd like to just quickly end on a quote, if you'll indulge me, from Liz Shanks, who's fought so hard for this transparency. And she said, "They're pretending to listen. They just want to be seen to be doing the right thing, but not doing what's actually needed. Crime victims are not being listened to. They're being let down every single day, and they'll be badly let down by this bill, which could have done so much more." And I find it hard to disagree with her, not least in respect of the plea deal amendment. So let's please show Liz and all the other victims out there that, in fact, we are listening and get these critical amendments across the line today. Thank you.
Thank you, Mr Finlay. I now call Jamie Green to speak to Amendment 64 and other amendments in the group. Mr Green.
Thank you, Presiding Officer. Can I start by adding my support to Amendment 38 in the name of Russell Finlay? I think he's made some very salient points well presented about the nature of information that victims get or do not get, as the case may be, and note his comments on that. My amendments in this group are in a similar vein, but rather than related to plea deals, these are amendments that are around where the Crown has decided to drop a case, in other words, decisions not to prosecute, as they're more commonly known. I've got two amendments in this group which both seek to achieve the same thing in slightly different ways, and I'll happily explain that. Amendment 64 will give victims a right to be informed by prosecutors when a decision has been made not to prosecute an alleged offender or to discontinue those proceedings against them. It does so by adding a new section into the Victims and Witnesses Scotland Act 2014, which states that where a prosecutor decides to discontinue prosecution or not to prosecute a case, then the prosecutor must, as soon as is reasonably practicable, inform the victim of this. Amendment 65 is materially similar, almost identical, but however it includes an extra caveat which says that unless the prosecutor considers that it would be inappropriate to do so, which gives prosecutors some necessary flexibility if they deem it appropriate. And this could be, for example, in complex cases where that information may, for example, put the alleged offender's safety at risk, where that has been identified, or may compromise future or simultaneous or concurrent investigations into the same alleged offender. I guess the question is similar to what Russell Finlay said about the plea deals and the lack of transparency, is why do we need this amendment or a version of it? The reality is, Presiding Officer, that it's too often the case that victims are just simply not informed that their case has been dropped or that a decision has been made not to continue prosecution. Now, at that point, many people will not have had the opportunity to opt in to any victim notification scheme, perhaps as those cases are not yet live in the system. So these are at that stage where the Crown has information from Police Scotland and is considering whether to pursue a case. Now, there are many reasons why they may drop a case, lack of evidence, or they believe that the case may not be successful, for example. But if someone has reported a crime and the Crown decides, for whatever reason, that they will not proceed with that case, then that person who has been identified as a potential victim ought have the right to know that. Now, you would expect that to be the case already, I think, but sadly, the reality is it is not the case. Too many cases are dropped or discontinued, and the victim is the last person to find out, if they find out at all. Now, the Cabinet Secretary suggests that because I've failed to provide some opt-out clause in this amendment, my amendments are not, I quote, trauma-informed. But that's not a concern which is shared by Victim Support Scotland, who I would say know quite a lot about trauma-informed justice practice. It is both my and Victim Support Scotland's assertion that Amendment 64 represents the strongest possible option by, I quote, creating a broad, unconditional notification duty covering both non-prosecution and discontinuation. My amendment also had very broad public support when I consulted on it back in 2001. 84% of respondents were fully supportive of my proposal when I consulted on my own victims' bill, that all victims should have the right to be notified of a decision not to prosecute their case. VSS have stated, and I'd like to put this on the record because I hope members will consider their opinion on this, we strongly believe that it should not be for a victim of a crime or their family to actively seek information about whether the crime is being prosecuted. It should be for the Crown Office and the COPFS or their representatives to proactively contact victims to inform them of these decisions. In cases where the victims are not told, then they cannot make use of their, for example, right to appeal such decisions in situations where it could be legitimate to do so. And we all know the reality that very few victims actually go on to appeal decisions not to prosecute, and the success rate of that is incredibly low. It is staggeringly low, actually. Indeed, Amendment 101 in Sharon Dowie's name, I think, it goes on to give an expanded version of what I'm seeking to achieve by offering that so-called opt-out clause that the government said was not in mine. So I'm happy to support Sharon Dowie's amendment if mine does not pass. But, Presiding Officer, this is not a new amendment. This was brought to the Justice Committee at stage 2 in March
of this year. So the reality is that if there have been any competency issues with its wording, if there have been any other issues that could have been flagged or addressed or even raised by the government ahead of today, they were not. Ultimately, it would have been preferable if the government itself had brought forward amendments to come up with a workable solution to this very live issue of victims not being notified of decisions not to prosecute. But in their failure to do so, I am urging Parliament to back my amendments in this group, as has been requested by Victim Support Scotland. The only other amendment which I will mention here is Amendment 38, because I don't believe it is a big ask. And I think this whole package of amendments in this group should be supported accordingly. Thank you, Presiding Officer.
Thank you, Mr Green. And I now call Sharon Dowie to speak to Amendment 101 and other amendments in the group. Ms Dowie.
Thank you, Presiding Officer. Amendment 101 requires that where a prosecutor makes a decision not to prosecute an offender, the prosecutor must inform the victim of this decision. I have, as Jamie Green said, included an important safeguard which I hope the Government will recognise as a compromise, which ensures victims can opt out of receiving this information in keeping with trauma-informed practice. It also gives ministers the power to make regulations for how victims could express their wish not to receive this information. It's crucial that victims are not kept in the dark, as they often report feeling like a witness in their own case, excluded from important decisions that concern them. It's common sense that where they want to receive this information, they should be kept informed about what is happening with their case. Victim Support Scotland and Scottish Women's Aid both support my amendment, with Scottish Women's Aid saying that providing information about the decision not to prosecute is important to women experiencing domestic abuse. My amendment would put victims first, and I move the amendment in my name. Thank you.
Thank you, Ms Dowie. And I now call the Cabinet Secretary.
Presiding Officer, let me make absolutely clear that this bill will deliver for victims. It will make landmark reforms that are, of course, much needed. And it's been informed by the voices of victims and their families and support organisations. And I have, of course, listened to Mr Findlay and indeed other members of this Parliament on the bill since it was introduced over 2 years ago. And the Chamber may be a wee bit surprised to hear that I've had constructive meetings with Mr Findlay and indeed took on board his contribution at stage 2 in relation to plea adjustments and offered to work with him for stage 3. And we agreed an approach to an amendment that we could both support, which enhances victims' rights, supports informed choice and strengthens the justice system's accountability. And that's Amendment 38, which I am very happy to support today. Of course.
Russell Findlay.
Due to the problems inherent within the criminal justice system of people being under strain and difficulties that prosecutors are under every single day, that an opt-in system is inherently flawed, and that victims might not even know they've got the right to opt in, hence the problems with our handout amendment.
Cabinet Secretary.
So, Presiding Officer, I think there are inherent flaws with an opt-out approach, which I will come on to, and I would like to put on record that I appreciate that due to the success of prosecutors and the rise in successful prosecutions of domestic violence and sexual crime, that the Crown Office does indeed work extremely hard and without a doubt will be under pressure. But it is, of course, a service that has seen increased funding by over 50%, 56% since the start of the last parliamentary term. And if I could address perhaps where we do agree, I agree very much that victims deserve to be kept informed, to understand what is happening in their case and to feel that the system is working for them and not around them. And what Amendment 38 does is it strengthens the rights of victims to be informed about plea adjustments. and it requires, by law, on the face of the bill, prosecutors to inform victims in solemn cases. And Amendment 38 not only delivers on the approach that I discussed and agreed with Mr Findlay, it actually goes further by including a power to allow for an extension to summary cases in the future. So I am a wee bit puzzled that Mr Findlay was not content with the approach that I outlined, and indeed why he lodged an amendment which he seems to be somewhat equivocating on, and has went on to lodge other amendments which he knows deny victims' choice, of course.
Russell Findlay.
So for the record, the Cabinet Secretary and I had discussions prior to recess, and nothing was agreed, nothing was set in stone. The Cabinet Secretary said she would go away and look at whether it would be an opt-in model or an opt-out model or something in between. And it was only right on the cusp of the deadline for lodging amendments that I saw the amendment which showed it to be an opt-in model, which I was never in favour of, hence my new amendments. And I'd like the Cabinet Secretary to at least acknowledge that as the case.
Cabinet Secretary.
Presiding Officer, I mean, what I would acknowledge in terms of the discussion we had, which will probably inform later debates and later groups, is I do think that the language around opt-in, opt-out is misleading and tends to create barriers on us coming together to agreeing the best ways forward for victims to receive information that recognises their agency, that recognises their choice, but also in equal measure builds systems that are far more proactive in reaching out to victims. My concern, Presiding Officer, in and around denying victims' choice is that this is what Amendment 63 would do. This amendment would compel prosecutors to contact victims who had expressly opted out of receiving information from the Crown Office. Individuals who, understandably, for their own reasons, for their own choice, may wish to move on from what has been a traumatic or distressing experience and not wish to have further contact with the Crown Office. To force information about plea adjustments onto victims in this way would be completely incompatible with trauma-informed practice being embedded in our justice system. And I would remind Mr Findlay that Part 2 of this bill creates a statutory duty for prosecutors to have regard to trauma-informed practice. I would have hoped that if Mr Findlay had listened to victims collectively, as he says he has done, he would not want to wholeheartedly support an approach that undermines that. Can I make some wee bit of progress and maybe later? Neither, Presiding Officer, do I support Mr Findlay's Amendment 102, which would make it the default that prosecutors had to contact all victims. That's having to contact all victims about plea adjustments unless they have specifically opted out. And that, in my view, unfairly puts the onus on precisely those victims who do not wish to engage. Turning to Amendments 64, 65 in the name of Jamie Green and 101 in the name of Sharon Dowie, I acknowledge the good intentions behind them. However, I have given them advance notice that I cannot support them. Choice and empowerment are core principles of trauma-informed practice. Victims should have meaningful control over whether and how they are kept informed about their case, if victims wish. And if victims wish, they can request to be told of decisions by the prosecutor not to take action in a case or to discontinue proceedings. However, Mr Green's Amendments 64 and 65 give the victim no choice about whether to receive this information. Under Amendment 64, they would simply have to be told, and under Amendment 65, it would be the prosecutor's decision with no consideration being given to the victim's views. While Ms Dowie's Amendment 101 does require taking the victim's views into account, it also requires the victim to opt out of receiving information specifically about a decision not to prosecute. And I consider victims should be supported and empowered to choose what information they would like at a time that is good for them, not forced to make decisions about individual pieces of information at particular and specific points in the criminal justice process. And that adds complexity to a system which victims already consider to be opaque and difficult to navigate. Of course.
Jamie Green.
I don't need to rehearse the arguments that we all know there are many issues with victim notification schemes as they currently stand. But the stark reality is that it is inconceivable that the Crown, particularly in grave cases, would just simply drop or discontinue proceedings and not tell the victim. Many victims are not signed up to these schemes because they were never invited to and were unable to have future opt-ins to these systems. Surely the default position should be that the Crown would want this information to be in the hands of the victims unless there was some explicit mechanism of not doing so.
Cabinet Secretary.
Presiding Officer, Mr Green won't find any argument from me in terms of the endeavours that must be made to improve the registration with victim notification schemes and indeed the Victim Information and Advice Service by the Crown Office. And we will get on to later groups in this debate that are part of that journey, good steps forward to improve the victim notification scheme in particular. The point I simply make is having a default position that requires prosecutors to contact everyone in all circumstances is blunt and is not trauma-informed. I understand very much what Mr Green and others are trying to achieve, but it would be remiss of me not to raise the issues that I have raised today. I would also ask parliamentarians to be aware about how the justice system operates in practice. So when a case is marked as no proceedings or no action, that often does not reflect a final or irreversible decision. Prosecutors retain the discretion to raise proceedings at a later stage if new evidence emerges or if other victims come forward. Yet, by mandating communication at this early point, as Amendments 101, 64 and 65 would do, risks misleading victims, creating confusion or unnecessary distress and ultimately undermining trust in the justice system. I'll take Ms Chapman.
Michael Chapman.
I thank the Cabinet Secretary for taking my intervention. Can she give us an indication of how many cases that have been marked no action do actually then get taken up at a later date? Because I think that there are victims and survivors who don't know, as Jamie Green and others have said, they just don't know what's happening, and they don't know whether there's even any possibility of future action taking place at all. And I think that's part of the unknown in this.
Cabinet Secretary.
Presiding Officer, unfortunately, I don't have the information at hand that Ms Chapman has specifically referred to, but I think the point she makes about a richer dialogue and better communication throughout the system is required, as is consistency of approach. And I suppose the fundamental point I'm trying to make here is, while we are all endeavouring to take advantage of this large landmark legislation to enhance it and make progress on issues such as this, that we just have to be mindful that if we take a more piecemeal approach, that we can actually add further confusion and complexity, when actually what victims are crying out for, amongst many things, is a coherence and a consistency in the system. Presiding Officer, with regard to... I'll take Ms Dowie.
Sharon Dowie.
Thank you. I'm listening to the points the Cabinet Secretary said, but we heard lots of evidence from victims, and their main issue was the fact that they weren't getting kept up to date with anything that was going on in the system. So surely, if the prosecutor at that point knows that they're not going to take any further action, they should be notifying the victim. And if further information comes up at a later date to say that they will then prosecute, then you would just go and update the victim yet again that they were now going to take further action. It should be best practice. It's just to keep the victims up to date so that they know what's happening in the procedures.
Cabinet Secretary.
The point I would make again, Presiding Officer, is not to dispute the need for thorough and regular communication. The point that I'm making around the amendments laid by Ms Dowie and Mr Green is that they are forcing information on victims whether they want it or not. And we all have to accept that victims and survivors are not a homogenous group. You know, that personal choice and empowerment and personal agency is, of course, important. That doesn't let...
Cabinet Secretary, could I just... sorry, just preempt you, Mr Rossiter, in a sec. I appreciate that, obviously, the Cabinet Secretary has been very generous in taking a lot of amendments, a lot of issues to go through, but I would perhaps ask her now to think about winding her remarks up, and then we'll go to Mr Finlay. Thank you.
Okay, I will, Presiding Officer, take your guidance. If I could also add, with regards to Amendments 64 and 101, that I have to advise that there are legislative competence concerns on the basis that would impinge on the Lord Advocate without allowing scope for prosecutorial discretion to withhold information, and this could be out with legislative competence of the Parliament. And, Presiding Officer, from an operational perspective, requiring blanket notifications would also introduce significant resource and pressures, both financially and in staff hours, due to the necessary increase in issuing correspondence and in managing follow-up contact questions and expectations from victims, some of whom may have already chosen, as I've said, not to engage further with the justice process. And this, of course, risks diverting resources from a more tailored, trauma-informed approach. Victims have a broad range of rights under the Victims and Witness Scotland Act 2014. I acknowledge more can and should be done to ensure victims are informed about how best they can exercise choice over the rights they have. That is why this bill will also establish a Victims Commissioner Victims Charter and improve the provision of information about support in the amendment on referrals that we will debate shortly. I consider those processes are a more effective approach than effectively duplicating existing rights or creating mandatory processes in a piecemeal fashion at very specific points in the criminal process. The focus should remain on improving quality, consistency and personalisation of victim engagement through the existing statutory framework and ongoing reforms, and I therefore urge members to support Amendment 38 and to reject the other amendments in this group.
Thank you, Cabinet Secretary, and I now call on Russell Finlay to wind up and to press or withdraw Amendment 38. Mr Finlay.
Thank you. I'll press Amendment 38. I find some of the Cabinet Secretary's reasoning to be slightly bizarre, to be honest. I've never met a victim who has argued that they don't want to know any more about their case, and campaigning strongly for even less transparency in a justice system which is already lacking transparency. Another fallback the government increasingly seem to be using is this talk of trauma-informed practice, which seems to be a catch-all, get-out-of-jail-free card for opposing anything that they don't like, which has no meaningful definition whatsoever, unless the Cabinet Secretary would like to enlighten me with... I will, yes.
Jamie Green.
I'm very grateful to the member. You would also note that in the briefing sent to MSPs, Victim Support Scotland, who I have a lot of time and respect for, who work day in, day out in their offices to support victims, support the amendments in this group. Therefore, I think we all should.
Russell Finlay.
Yeah, absolutely. Victim Support Scotland support my 3 amendments, and indeed Scottish Women's Aid support one of them. I will.
Cabinet Secretary.
Thank you. I'll be brief, Mr Finlay. Given that Victim Support Scotland are encouraging MSPs to back this bill tomorrow, I wonder if he'll confirm whether his party will do so.
Russell Finlay.
Well, what we will do is do what we're doing right now and what we've done for the past couple of years, and is try and improve this bill, which is a massive missed opportunity. And then we will look at it tomorrow. And I'm not encouraged by the Cabinet Secretary's refusal to back these common sense amendments. That's not a good sign. Thank you.
Thank you, Mr Finlay. The question is that Amendment 38 be agreed to. Are we all agreed? Yes. The Parliament is agreed. I call Amendment 63 in the name of Russell Finlay, already debated with Amendment 38. Russell Finlay, to move or not move?
Moved.
Thank you. The question is that Amendment 63 be agreed to. Are we all agreed? No. The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 63 in the name of Russell Finlay is yes 50, no 64. There were no abstentions. The amendment is therefore not agreed. I call amendment 102 in the name of Russell Finlay, already debated with amendment 38. Russell Finlay to move or not move?
Move.
Thank you. The question is that amendment 102 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Point of order, Tim Eagle. Perhaps, Mr Eagle, now that your microphone is on, could you perhaps repeat for the record?
Apologies, some connection issues there. I would have voted yes.
Thank you, Mr Eagle. Your vote will be recorded. Thank you. The result of the vote on amendment number 102 in the name of Russell Finlay is yes 51, no 57. There were 7 abstentions and the amendment is therefore not agreed. I call amendment 64 in the name of Jamie Green, already debated with amendment 38. Jamie Green to move or not move?
Moved.
Thank you. The question is that amendment 64 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. The result of the vote on amendment number 64 in the name of Jamie Green is yes 58. No 56. There were no abstentions. The amendment is therefore agreed. I call amendment 65 in the name of Jamie Green, already debated with amendment 38. Jamie Green to move or not move?
Not moved.
Not moved. And so I call amendment 101 in the name of Sharon Dowie, already debated with amendment 38. Sharon Dowie to move or not move?
Moved.
Moved. The question is that amendment 101 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. I call Katie Clark for a point of order.
There was a technical problem. I voted yes.
Thank you, Ms Clark. Your vote will be recorded. Thank you. The result of the vote on amendment number 101 in the name of Sharon Dowie is yes 53, no 61. There were no abstentions. The amendment is therefore not agreed. We now turn to Group 8, Victim Notification Scheme and Rights to Make Representations. I call Amendment 66 in the name of the Minister, grouped with amendments as shown in the groupings, and I call on Minister Siobhan Brown to move Amendment 66 and to speak to all amendments in the group. Minister.
Thank you, Presiding Officer. Further to amendments passed at Stage 2 to reform the Victim Notification Scheme, or VNS. The amendments in this group will help to deliver a more trauma-informed approach to the VNS. The VNS has a criminal justice and a forensic mental health aspect. The latter relates to victims of patients in the forensic mental health system subject to the compulsion order and restriction order. This is the CORO VNS. All my Stage 3 amendments will deliver reforms across both the criminal justice VNS and the CORO VNS unless otherwise stated. Presiding Officer, let me start with Jamie Green's Amendment 85. I know he's going to have the opportunity to speak shortly, and he is aware that we cannot support it, although I have to say I am sympathetic to the intention. The Scottish Prison Service, or SPS, and the Parole Board for Scotland have been clear that Amendment 85 would not actually result in a better service for victims. The additional process steps that would be needed would create delays for victims, and that kind of barrier is at odds with our ambitions for the VNS reform and the rest of the amendments on the VNS, so I would urge Mr Green not to press. Presiding Officer, turning to the government amendments, I will speak first to Amendment 66, linked to Amendment number 94. These take forward recommended reforms to the VNS eligibility where a victim has died or is incapacitated. Currently, where a victim has died, the first 4 eligible relatives from a strict hierarchical list can join the VNS. And where a victim is incapacitated, the highest qualifying relative from that list can join. We know that this approach is inflexible and it causes distress. So Amendments 66 and 94 will change this to be based on the nature of the relationship with the victim, not the current list. So where a victim has died, it will be possible where a victim has died, it will be possible for 5 people to join the VNS in total rather than the current 4. The Scottish ministers will also be able to enable more people to join the VNS by way of regulations, ensuring future flexibility. Now, this discretionary decision-making will be underpinned by the Code of Practice, which will also govern decisions on a child victim joining the scheme. The Code is to be published in draft, consulted on and laid before Parliament, reflecting its importance. Amendment number 67 comprises a set of changes which will support a key aim of VNS reform: parity of treatment for victims where appropriate, regardless of where the offender is held. It does this by ensuring that victims of child offenders sentenced to detention in secure accommodation can benefit from the same rights under the VNS as victims of offenders held in prison or in young offenders institutes. Amendment 68 will deliver a recommendation from the independent review by introducing a bespoke decision-making process in relation to a child victim who wishes to join the VNS. A determination on who will receive the information will be made based on the child's age, views and best interests. Amendment number 94 also provides that the approach to child victims will be... Yes, Sharon Dowie?
Sharon Dowie.
Sorry, it's just a clarification for Amendment 68. It imposes a test where ministers will decide if information about the release of an offender should be directly given to a child and have regard to their age and maturity in doing so. Just to see if you could clarify if there's any circumstances where a 17-year-old would request this information but be denied it.
Yes, so the child's best interests are going to be at the heart of how decisions are made and whether child victims will be able to join the VNS in their own right. And we recognise that in some cases these decisions will be finely balanced, especially about age, but I want to be clear that we will seek to accommodate a child's wishes as far as possible. Amendments 69 and 95 make provision to enable victims to nominate a person to receive information at the same time as or instead of the victim, which is also a recommendation from the VNS review. Presiding Officer, Amendments 70, 77 to 81 collectively deliver key improvements to victims' rights where a cross-border transfer of an offender or patient takes place, in line with the recommendation from the independent review, making it easier for victims to exercise their rights once a transfer has taken place, including transfers into Scotland. Amendments 70 to 8 and 80 will enable victims to be advised of the jurisdiction to which the offender in their case is being transferred, unless this is not in the interests of justice. This is a crucial change which will help provide peace of mind to victims, and Amendment 71 enables Scottish ministers to provide victims with information ancillary to the core information that they receive under the VNS, to provide flexibility and more meaningful information for victims. Amendment 72 has two main parts. First, it amends existing order-making powers for the VNS so that they can be used to make a wider range of changes to the information available under the scheme than is possible under the current powers, ensuring greater flexibility. Second is the response to the VNS's review recommendations that victims should be able to be told of each occasion of temporary release from prison, where that might bring the offender into close proximity with the victim. Engagement with stakeholders indicated there were a range of conflicting views on this recommendation, so we are taking the power now that we will enable future changes by way of secondary legislation, and this will give us the opportunity to consult on these issues and build a consensus with stakeholders on the way forward. Presiding Officer, Amendments 73 and 74 are technical amendments which build on provisions agreed at Stage 2. Amendment 74 enables Scottish ministers to make regulations which impose a duty to cooperate the ministers for the purpose of the VNS on other persons, future-proofing the scheme in case of expansion. We will consult before progressing such regulations. Amendment 74 will also facilitate better access to information for victims where a cross-border transfer occurs by ensuring that the Scottish ministers can cooperate with other relevant persons. Amendments 73 and 75 are consequential changes to Stage 2 amendments. Amendment 82 delivers a recommendation from the independent review on the information available under the Coro VNS that will enable all victims registered for the Coro VNS to receive information about an appeal against recall being lodged and about the outcome of such an appeal. Amendment 161, in the name of the Cabinet Secretary, makes changes to the long title of the bill to reflect the amendments in my name in this group. And, Presiding Officer, I am sure this Parliament shares my ambitions for VNS reform, and I urge Parliament to support my amendments in this group, and I ask Mr Green not to press his, and I move amendment number 66.
Thank you, Minister. Jamie Green to speak to Amendment 85 and other amendments in the group. Mr Green.
Thank you. I'm going to keep my comments solely to my amendment in this group. There are a number of amendments in this group. I think, as we've discussed a lot already, the VNS scheme at the moment is just simply not fit for purpose. And I do understand that the government acknowledges that, as do other stakeholders, and I hope to see some meaningful reform to it post this legislation. This legislation cannot be the first or last step in improving the entire end-to-end process about how victims are notified, what they are told, when they are told it. And as part of today's deliberations, we are trying to improve that, as the last group, I think, demonstrated. There is cross-party support, even when there is not government support for such changes. I want to talk to Amendment 85, which is particularly around the information that a victim will receive prior to someone's release as part of the parole process, or once their time has been served. Amendment 85 essentially says that the victim must be informed of a prisoner's date of release prior to the prisoner being released, unless it is not practical to do so. Now, at the moment, Section 16 of the Criminal Justice Scotland Act 2003 sets out all the information that a victim is entitled to receive in relation to the release of an offender. But most importantly, it does entitle them to that information about the date of the convicted person's release. My amendment will not change any of that. It will not change the information provided to a victim, but it does be explicit in saying that that victim should receive that information prior to the event, prior to the offender being released. Section 17 of that same Act sets out decisions, information that a victim is entitled to following decisions made by the Parole Board. And as such, the second part of my amendment clarifies the parameters about how and what information someone will receive. If you look at Amendment 85, subsection 3, it says that as soon as reasonably practical, after any decision is made, that is to say, after the Parole Board has made a decision about someone's release or not, the victim must receive information about whether or not to recommend or direct the release of that person, and whether the person released is to comply with conditions. As we often know, conditions are often attached to these parole decisions. And B goes on to say where the person is to be released. But more importantly, it says before the date of that release. Before the date of that release. Now, I would go as far as saying that this amendment or this change to the 2003 Act should not be necessary. It is my view, and always has been, that it should be the case that victims are told before release, not after. It is inconceivable that people are discovering that someone has been released, having opted in to receive that information and being entitled to receive that information under the 2003 Act, to then get that information after the event has happened. More so when, as we know, in the last couple of years, this Parliament has passed legislation around early release and emergency release. I understand there are practicalities associated with this. It will require some work on behalf of whichever body is responsible for that information to be disparted. It must happen, though. It is absolutely paramount that victims are told before someone is released. They do not want to bump into them in a supermarket or on the street or at the end of the road or standing at a train station platform. And I'm not making these scenarios up. These are real experiences that have been relayed to the Justice Committee as it delivered its evidence. This happens at the moment. Victim Support Scotland told me that only 2% of victims, 2%, were notified of the perpetrator's release when the government released hundreds of prisoners in its early release system last year. It is simply not good enough to tell people after the release has occurred. My amendment will go some way to ensuring that this is not the case. Yes, I'm happy to take an intervention.
Minister, briefly.
For taking the intervention, and I think we all wish the same for the VNS moving forward. I just know that, Mr Green, when you consulted on your proposed victims...
Through the Chair, please, Minister.
Sorry, Presiding Officer, your proposed victims bill, and I just would find it would be helpful. Did you have any responses from the SPS or PBS regarding the timings of the information provision when you consulted?
Still through the Chair.
Thank you.
Jamie Green.
Well, first of all, when a member does a consultation on a member's bill, it is up to individual organisations to choose to participate in that consultation. It's not for me to say you must respond to my member's bill consultation. Indeed, it was widely consulted. That was 4 years ago, I should add to the Minister. There's been ample opportunity for the Parole Board or any other organisation who had concerns about that particular proposal in my consultation to make them known to us. Equally, at stage 2, this matter arose. That was back in March. No such organisation has made representation to the contrary of my proposal, nor has the government, nor has any counter-proposals been forthcoming. So what I would say to the Minister is if there were any issues around what I'm proposing, there's been ample opportunity to both raise them and come back with an alternative solution. It remains my fundamental belief that people should be told of these decisions before someone is released. That is a moral obligation on all justice partner stakeholders to do that. and Victim Support Scotland support this. They want to know when that person is released and if there are conditions associated, so they can plan for their own safety and get support. And I quote directly from VSS on that matter. And so I urge members to support Amendment 85.
Thank you, Mr Green. I call on the Minister to wind up. Any further comments?
No, thank you, Presiding Officer.
Thank you. The question is that Amendment 66 be agreed to. Are we all agreed? Parliament is agreed. I call Amendment 67, 68, 69, 70, 71, 72, 73, 74, 75, 76, 77, 78, 79, 80, 81 and 82, all in the name of the Minister and all previously debated. I invite the Minister to move Amendment 67 to 82 en bloc.
Moved en bloc.
Does any member object to a single question being put on Amendment 67 to 82? That being the case, the question is that Amendment 67 to 82 be agreed. Are we all agreed? Parliament is agreed. We move to Group 9, Victim Statements. I call Amendment 39 in the name of Jamie Green, grouped with Amendment 104. Jamie Green to move Amendment 39 and speak to both amendments in the group.
Thank you. This is a short group, but I have the first amendment, this Amendment 39, which is around victim statements. Let me start with why we need this amendment. As it stands, Section 14 of the Criminal Justice Scotland Act only allows victims of prescribed offences to make victim impact statements to a court, and only in solemn proceedings. Those prescribed offences, for example, include the obvious: murder, rape, culpable homicide, raised fire and a few others. This list of offences was last updated in 2009, and it excludes victims of many serious offences which have been created since the 2009 review, including domestic abuse legislation which has been passed by this Parliament and others. Effectively, what it's done is create, in my view, an unfair two-tier system where some victims' voices are heard in the courtroom and others are not. And I believe this has had a tangible effect on the information that is available to judges prior to sentencing, and indeed may have resulted in sentencing decisions based on that lack of information and that lack of that victim's voice. Now, the natural solution to this could have been to simply update the list of prescribed offences. But as I said during Stage 2 proceedings when I raised this issue, updating the list wouldn't future-proof this bill and this particular amendment. Put simply, I don't think it is realistic to expect ministers to have to update the prescribed list of offences at the pace in which legislation is changing and any new offences which are created. My Amendment 39 takes a different approach. It simply expands the franchise to all victims in all solemn proceedings. So it does this by making changes to Section 14 of the Criminal Justice Scotland Act, notably by replacing the word prescribed offences. This new subsection sets out that a victim, I quote, of any offence, in the case of solemn proceedings, can be afforded that opportunity to make a victim statement. I think, crucially, this amendment expands the existing powers of the Scottish Government in the future to perhaps trial this in non-solemn proceedings, although I understand, I think in a point made by Russell Finlay in earlier debates, that expanding this to summary cases would result in a huge volume of impact statements. But I'd still believe there may be a place for it in certain solemn proceedings and certain prescribed offences in summary proceedings as well. I'm also grateful for cross-party support for this amendment, and particularly for the support from Ben McPherson, MSP, who approached me with some deeply troubling casework that he had been working on and believed that this was the right thing to do. The Minister often likes to refer to my own consultation. I'm happy to confirm that 85% of respondents in this consultation supported the proposal to expand the franchise for victim statements in court. Victim Support Scotland, once again, and I'm grateful for the support, support it. And I think they make a very valid point when they say that the supposed seriousness of an offence has very little bearing on how that individual has been impacted by the offence. Therefore, they say anyone who has been impacted by a crime should be able to make a victim impact statement, should they wish, regardless of the nature of the offence or the court in which it is to be heard. So I urge members to support that, and I'm grateful to the Government for acknowledging that this massive change has had to happen, was long overdue, and as a result of today's business, hopefully will pass, and we'll see that change that will benefit future victims of crime. I also note Sharon Dowie's Amendment 104, which is the second of this group, which enables the victim, if they so choose, to read that statement aloud in court proceedings. Now, my concern is really not with the intention behind this. Indeed, I support the expansion of victim statements in court environments. My issue, though, is more of a technical one, and that is, as I read the amendment as drafted, that if a victim statement has been made, then it must be read aloud in court, either by the victim or, if they choose not to, by a judge. The problem with that is there is no opt-out, that if a statement exists, then it will be read aloud, come what may. That doesn't cover scenarios where, for example, the victim may wish a judge to read the statement prior to sentencing, but may not wish that to be read aloud in public knowledge. But I'm happy for either the member or the ministers to confirm my interpretation of that before we decide on voting. But nonetheless, I do commend Ms Dowie for bringing it to the Chamber, and I hope that she and other members will support my amendment in this group.
Thank you. I now call on Sharon Dowie to speak to Amendment 104 and the other amendment in the group. Ms Dowie.
Thank you, Presiding Officer. My Amendment 104 requires that, in cases where the victim is eligible to make a victim impact statement, the court must allow for the statement to be read aloud in court. There is currently no requirement for a victim impact statement to be read aloud in court, but I think the voices of victims must be heard. The statement could be read by the victim where they have requested to do so, or by the judge or sheriff. Given concerns about the possible length of these statements, I have provided that the court has discretion as to whether the statement is read out in whole or in part. Victim Support Scotland and Scottish Women's Aid have both expressed support for my amendment. I worked with Victim Support Scotland closely on this, and they told me that one of the main issues with victim impact statements is that victims spend time writing out their feelings with the expectation that this will be shared in court, but they have no idea whether their statement will be read out or not. This most certainly causes victims unnecessary anxiety in an already stress-inducing and traumatising situation. Scottish Women's Aid say they back it because this process needs urgent attention and reform, particularly supporting women's agency and their right to make a statement. Yes.
Mackay.
Member for taking the intervention. I just wonder if the member would acknowledge that this could have the effect of disempowering a victim. If they don't want the statement to be read out, they may be re-traumatised or whatever. And is that not taking choice away from the victim?
Sharon Dowie.
Okay. Thank you. I was actually going to come back to that point just in answer to Jamie Green, but in the section where it says the person who made the statement, if that person requests to do so. So that was the point that I was trying to get, where if they wanted to do it, they didn't have to do it. But if they wanted to do it, then they could read it out aloud in court. Throughout all the evidence sessions that we've done in the committee, we've heard from lots of victims who basically said that they felt they were a witness in their own case and they didn't get the chance to speak. They felt as if the key points of their case were not brought up in court. They had no engagement, and this would actually give them the chance to actually say to the court what the impact of the crime had on them. Sorry, Graham Simpson.
Graham Simpson.
Oh, it's online.
Can I thank Sharon Dowie for taking the intervention? I just want to be clear on this point about the way the amendment is worded, and perhaps Sharon Dowie can clear this up. It seems to be that if there is a victim statement, then it must be read aloud in court. It must be read aloud in court. And that is the wording of the amendment. So irrespective of whether a victim wants it to be read out or not, it must be read out aloud. Is that correct?
Sharon Dowie.
The way the amendment is drafted, the intention was that if the victim wants a request that it should be read aloud in court, then it would be allowed to be read aloud, because they don't have that choice at the moment. It would then mean that they could either read it if they requested to do so, or they could get the judge or the sheriff to read aloud. And again, the discretion is, it could be a long statement, it could be a short statement, but it then allows them the discretion to maybe just read part of the statement rather than the full thing, because obviously there's time restraints in court. Yes, no problem.
Cabinet Secretary.
I wonder if she could respond to the effect of her amendment is that it makes mandatory for the victim's statement to be read aloud in court, either by the victim themselves if they request to do so, or by the judge or sheriff if the victim does not wish. So my interpretation of that is that the statement has to be read out either by the sheriff or the victim, and that the only discretion that is available is for it to be read in full or only in part.
Sharon Dowie.
Yes, and that's where the discretion is, that they could read it in part, so it could be shortened. So it could be the full statement that could be read out, but the key points in the statement could be made aware to the court. Okay, so take one more thing.
Audrey Nicholl.
Member for giving way. I'm just wondering, I'm quite concerned about this amendment. I understand the rationale for it, but I wonder if the member has considered what support or guidance would be provided to a survivor in preparing their statement, because it has got quite big implications for them to read it out in an open court, and they may seek guidance on what to include and what not.
Sharon Dowie.
Thank you. Well, at the moment, they've got the support of Women's Aid, they've got the support of Victims Support Scotland, there's people in the court that help them along the way, and if that's something else that we should be directing funds towards to make sure that we're dealing with victims in a trauma-informed way, then that's something that I think we should then look at. But it's one of the key points that we heard, taking all the evidence, was that victims felt as if they were completely ignored and they were a witness in their own case, and they felt that they didn't have any involvement. So this gives them the opportunity to say it for themselves in the court. It allows them to have the judge or the sheriff to read it out, or the judge and the sheriff have the opportunity to shorten the statement, but it gives them the ability to do something that we've heard in committee that they've not been allowed to do. And I move the amendment in my name. Thank you.
Thank you, Ms Dowie. And I call Ben McPherson.
Thank you, Presiding Officer, and I'm grateful for the opportunity to speak to Amendment 39 in support of Jamie Green, and recognise and I'm grateful for the engagement with him and his team, and also with the Scottish Government. I think this issue of victim impact statements is important for all of our constituents who are affected by crime. And this was brought particularly to my attention by one of my constituents, Leslie, who came to see me at my surgery expressing their concern, and I have permission to say their first name, I should be clear, their concern that in their situation, the person who was convicted of crime against them did not hear from the court process the effect that it had had on Leslie's life. And therefore, with this bill going through Parliament at the same time, it was great to be able to collaborate with another member and with the Government to bring this change, which for more people at their discretion, and I do have issues with Sharon Dowie's Amendment 104 because it doesn't seem to give that discretion and that choice. I don't think the drafting is effective in giving that choice, having looked at it carefully. So I think Amendment 39 in itself is what Parliament should vote for, to enable more constituents, if they want to have their victim impact statements heard and read, so that the effect that a crime has had on them is understood by the person who is being tried in the case. So, for all those reasons, and to help our constituents, including my constituent Leslie, I would urge Parliament to support Amendment 39.
Thank you. And I call the Cabinet Secretary.
Presiding Officer, Amendment 39 is another area that I have been pleased to have been able to work with Jamie Green on. As has been outlined already, it will expand the eligibility to make a victim statement to all victims in all solemn proceedings, and is a significant step in a broader programme of work to improve the victim statement scheme, ensuring victims have a meaningful voice in all solemn proceedings. Ensuring that victims are given this meaningful voice in our criminal justice system is a fundamental step towards a more compassionate and trauma-informed approach, and I urge Parliament to support this amendment. Presiding Officer, Scottish Ministers already have powers to pilot different ways a victim statement can be made. This allows us to take a considered step-by-step approach to widening how victim statements are provided, which is why, in addition to supporting Amendment 39, let me inform the Chamber that in my letter to the Criminal Justice Committee on the 5th of September, I committed to conduct a pilot of alternative formats for making victim statements within the Sexual Offences Court if the bill passes tomorrow. And this is important. At present, victim statements can only be made in written form. In my view, it's important that alternative formats are trialled, whether that's pre-recording or indeed in person, recognising the importance to victims who wish that opportunity to reflect on the impact of crime, not just in their own words, but in their own voice. But choice is, of course, imperative, because not everyone will feel safe or comfortable reading out their statement in an open court. And I'm happy to give way to Mr Green.
Jamie Green.
Can I thank the Cabinet Secretary for that additional information? That is very welcome news. I think there are other cases, particularly in our summary courts, that still are relatively serious, where a victim does not have a voice. I think one of the things that the debate has thrown up today, particularly around Sharon Dowie's amendment, is the issue around empowering victims to choose the manner in which those statements are made, and indeed if they want that statement to be made. And whilst I think there could have been an easy fix to Amendment 104, which would have been a technical tidy-up to make it more palatable in terms of that opt-out, which I don't think exists in its current drafting. But the point being made, though, is an important one, and that's that more people should have their voice heard in courts. Amendment 39 will go some way to do that, but I do believe that the Government still could go further in making sure that all victims are both aware of their right and aware of the methods by which they can ensure that their voices are heard in courts.
Cabinet Secretary.
Presiding Officer, I do believe that through Amendment 39 and the pilot that these are constructive strides forward that will help victims to reclaim their agency, acknowledge their experience and, crucially, support their recovery, all of which is at the very heart of the culture that we wish to establish through the creation of a standalone sexual offences court. And I reiterate the point, there is always more to do. Presiding Officer, I cannot support the other amendment in this group in the name of Sharon Dowie, and I would urge her not to press. Amendment 104 would make it mandatory for victim statements to be read aloud in court, either by the victim or, if not requested by them, by the judge or sheriff, whether they wanted that or not. It is vital that victim choice is respected. Making it mandatory that statements are read out loud in court removes victims' ability to choose how their personal experiences are shared. This undermines trauma-informed practice, which is built on the principles of choice, autonomy and empowerment. Mr Kerr.
Liam Kerr, briefly.
I'm very grateful. Just listening to what the Cabinet Secretary is saying, Victim Support Scotland are very clear that they support this Amendment 104. So how does she respond to that?
Cabinet Secretary.
Well, I hope Mr Kerr and his colleagues will bear in mind the voice of Victim Support Scotland when we get to vote on the final passage of this bill tomorrow. But in terms of this amendment, sirs, just a wee tiny bit of patience. I do believe that the pilot is the best way forward in the context of the Sexual Offences Court, and the pilot would enable a full range of alternative formats of making victim statements, including, of course, and I'm already on record of saying that there is an intrinsic value of victims having the opportunity and choice to make their victim statement in their own words, but also in their own voice. Presiding Officer, in terms of Ms Dowie's Amendment 104, I believe it could have unintended consequences of leading to victims either not using their opportunity to offer a victim statement at all, or if they do, providing a statement which does not offer the same level of insight to the judge to help inform sentencing. And this is because many statements may contain extremely sensitive information where disclosure in an open court is not wanted by the victim. Victim statements are central to ensuring a judge understands the victim's experience and the impact a crime has had on them, and that can be reflected in their sentencing decision. So anything that could impact that would be an unwelcome step backwards. It would also, I have to say, cut across Jamie Green's Amendment 39, which expands victim statements, as if we are to see people not take up this opportunity due to its mandatory nature of being read in open court. The benefit of that expansion could be lost. And on that basis, I would ask members to support Amendment 39 and oppose Amendment 104.
Thank you. I call Jamie Green to wind up. Press to withdraw Amendment 39. Mr Green.
Thank you, Presiding Officer. Very briefly, can I thank the debate, members for the debate we've had. I think it's been very constructive. I think it does, as often these things do, flag up as where an amendment has come forward from an opposition member, which is very well intended, as I believe Ms Dowie's was, but the technicality of the drafting is perhaps we're unable to support it. However, that's an issue that crops up frequently and could be addressed. The government has ways and means of fixing amendments that it agrees with in principle, but doesn't agree with the competency of. And we've already seen a number of manuscript amendments submitted by the government since the digital deadline passed. So I don't really understand why the government couldn't have picked up on the deficiencies in Ms Dowie's amendment. And I apologise for not being able to support the wording as it is, but do commend her for bringing it forward. Back to the substantive point about this group, and that's victims being able to make statements in courts. I think it seems like a small amendment, and I know it's a long day and there's lots of amendments going through, but I do want the wider public to know about the importance of this one. As of now, if this passes and if the bill passes tomorrow, then all victims of crime who have their cases heard in solemn proceedings will now have the ability to make a victim impact statement to court in a manner of their choosing, if they so wish. And that franchise just simply does not exist at the moment, and I think it's a really positive step forward for our justice system, and it will be a good day for victims if that passes. Thank you, Presiding Officer.
Thank you. The question is that Amendment 39 be agreed to. Are we all agreed? Yes. Parliament is agreed. I call Amendment 104 in the name of Sharon Dowie, already debated with Amendment 39. Sharon Dowie, to move or not move?
Not moved.
That is not moved. We move to Group 10, Court Transcript. I call Amendment 83 in the name of Audrey Nicholl in a group on its own. Audrey Nicholl to move and speak to Amendment 83.
Thank you, Presiding Officer, and I move Amendment 83 in my name. This amendment would enable survivors of rape and sexual offences to access court transcripts from the Clerk of Justiciary free of charge. So for context, at Stage 2, I moved a probing amendment on this issue, joining Pauline McNeill and Jamie Green, who lodged similar amendments and welcomed the Cabinet Secretary's commitment to engaging further on this issue in advance of Stage 3. So the difficulties that survivors have historically experienced in accessing a record of a trial were first brought to the attention of the Criminal Justice Committee in 2021, and I pay tribute to the women who described the challenges they faced, with one having to pay more than £3,000 for a single transcript. So for some survivors, access to transcripts has a practical function when they might be involved in another process, for example, in the civil space. For many, access to a record of what was said during a trial is an extremely important part of their recovery and closure process. And it reflects a justice system that is trauma-informed and trauma-responsive. I'm very grateful to the Cabinet Secretary for agreeing to the establishment of a pilot enabling survivors to access transcripts for free, and for extending the pilot beyond its original timeframe in order that a number of operational considerations, such as developing emerging technology, evaluation of the potential demand and potential legislative changes, could be considered more fully. So my Amendment 83 seeks to add a new subsection into Section 94 of the Criminal Procedure Scotland Act of 1995, which requires that a transcript is made and sent to a complainer at no cost. Now, this applies to cases involving sexual offences listed in Section 288C of the 1995 Act, which were heard in the High Court or the Sexual Offences Court and which commenced on or after the 31st of December 2026. So I'm very grateful to Scottish Women's Aid, Victim Support Scotland and other organisations for their support regarding this amendment. I will.
Russell Finlay, briefly.
Just wondering if the member has given any consideration to extending this amendment to other serious cases prosecuted in the High Court or Sheriff Court at Solemn level.
Audrey Nicholl.
I thank Russell Finlay for his intervention, and I know that that is something that has been proposed and given some thought, but perhaps that's something that the Cabinet Secretary would be able to comment on. So just to conclude, Presiding Officer, I urge all members to support this amendment, reflecting our commitment to ensuring our justice system responds effectively to the very unique needs of victims who have suffered complex trauma, putting their needs front and centre always. Thank you.
Thank you. I now call Pauline McNeill.
Thank you. I want to speak in support of Amendment 83 and for the work that Audrey Nicholl has done on this. As she said, myself and Jamie Green also supported Audrey Nicholl in support of transcripts being extended for the reasons that she says. Victims often told us in the work that the committee has done that they don't feel at the centre of something of which they're the complainer. And being able to read back what happened in a trial where you are at the centre of it is very, very important for the recovery process. In conclusion, I do want to fully commend the Cabinet Secretary and the Scottish Government for taking this as a bold step. And I'm absolutely certain that complainers and those who came to the committee to argue for it will be delighted if the Parliament passes this amendment today. Thank you.
Thank you. And Jamie Green.
Thank you. Just to add to what's already been said, there were a number of us who came to the committee at stage 2 around this issue of court transcripts. It's been bumbling along the Justice Committee for many years, and a range of stakeholders have expressed quite strong views on it. I absolutely understood the issues around expanding the franchise to all victims in all cases, and that all transcripts must be available to everyone at all times. There are, pragmatic issues around that, cost issues around that. But also, as we've later learned, issues around data protection, privacy, GDPR and redaction issues, which cannot be dealt with in an artificial intelligence manner. So I am pleased that this amendment sits, but I think, as we heard in an earlier intervention, there is a discussion, a wider discussion should be had about expanding this to other offences. I think it's also worth noting that a number of survivors of particularly sexual offences were very keen to do this. They've gone through horrific experiences in pushing the government. For many years they've been lobbying for this change. And people like Ellie Wilson and others who, to their credit, have been banging the drum for expanding access to court transcripts. But whilst we're expanding it to a group of people who will benefit from the amendment today, there are many others who will not. And I hope the government could reflect on that. I would personally like to see a piece of work done by somebody in the justice system or in the Civil Service Directorate responsible for it, a wider piece of work about how we can use technology to improve faster, cheaper and better access to court transcripts for any victim of any crime, should they so need it, particularly those who have moved out of the criminal proceedings and are taking their case, for example, through civil courts, where there's an absolute need and a necessity to access those transcripts. So I hope that's something that the government will consider, but either way I hope the Chamber will support this small step forward.
Cabinet Secretary.
Presiding Officer, I want to thank Audrey Nicholl for bringing forward Amendment 83 following our discussions at Stage 2. We introduced the current pilot in March 2024 in response to victims highlighting that the cost of paying for transcripts can be prohibitive. As a result of the pilot, there have been over 120 applications made. We anticipate that the total funding for the pilot will be in the region of £300,000 by the time of its conclusion in February 2026. The evidence to date suggests that the pilot has had a positive impact that was envisaged. And I am pleased to be able to support Amendment 83, which will give victims of sexual offences a statutory entitlement to free transcripts and therefore secure on a permanent basis the outcomes achieved through the existing court transcript pilot operated and managed by the Scottish Courts and Tribunal Service. And in terms of the point about expanding to other cases, point made by Mr Finlay and Mr Green, I think any expansion needs to be financially sustainable and one which I would have to discuss with the Scottish Courts and Tribunal Service. But I would be hopeful that with improvements in technology that would reduce some of the costs in this area. And meantime, Presiding Officer, I'm hopeful that members will be supporting Amendment 83.
Thank you. I call Audrey Nicholl to wind up. Press to withdraw Amendment 83.
Thank you, Presiding Officer. And can I thank colleagues Pauline McNeill and Jamie Green for their support. This is a small but hopefully important piece of cross-party work, and it's great to get cross-party support on it. I'd also like to thank the Cabinet Secretary for her support again. I endorse and agree with all the points that were made by colleagues with regard to extension of this provision. There are practical and cost implications, but maybe this is the beginning of a wider discussion. So to conclude, I press Amendment 83.
Thank you. The question is that Amendment 83 be agreed to. Are we all agreed? Parliament is agreed. It takes us to Group 11, referrals to victim support services. Just to advise the Chamber, we'll complete this grouping and then have a short comfort break. On that basis, I call Amendment 84 in the name of the Cabinet Secretary, group with Amendment 103. Cabinet Secretary to move Amendment 84 and speak to both the amendments in the group. Cabinet Secretary.
Presiding Officer, I would like to open this group by offering my thanks to Jamie Green and Maggie Chapman for highlighting this issue, and to Mr Green for supporting my amendment today, which builds on the one that he brought forward at stage 2. I would also like to acknowledge the work of Victim Support Scotland in championing a more proactive referral process, and we have a shared objective to ensure victims get the support they need when they need it. Since stage 2, we have worked closely with Police Scotland to develop an amendment that is rights-based, trauma-informed and respects victim autonomy and choice. At present, the law requires the police to inform a victim that they may request a referral to providers of victim support services. My Amendment 84 puts a duty on the police to inform a victim, and they are entitled to be referred to a victim support service and to explain what is meant by support service and a referral. My amendment will place a proactive duty on the police and seeks to ensure victims understand that they have a right to be referred and the nature of support available. It seeks to normalise being referred to support services by stating that it is an entitlement rather than something that the victim may request, and empowers victims to make an informed decision. It will also require the Chief Constable to produce guidance on the referral process. For the processing of personal data to be compliant with GDPR, it needs to be necessary and proportionate, as well as transparent and fair. Passing on people's data without their consent rightly needs to be necessary and proportionate. An individual has a right to privacy. Our consultation with the Information Commissioner's Office reinforced the significance of adherence with the principles of necessity and proportionality, transparency and fairness, and of the need for consent to be informed, affirmative and explicit for the sharing of personal information, and my amendment provides such a model of consent. It is essential to ensure that any referral process is compliant with those principles. If we do not do so, we risk passing an amendment that cannot be operationalised by the police and there is a significant risk that it would fall foul of the data protection regime. Maggie Chapman's Amendment 103 would see the referral mechanism being one that victims need to opt out of. However, if we do not provide for explicit consent from victims, it poses the very risks I have mentioned of non-compliance with data protection legislation and ultimately being inoperable. Furthermore, I would be concerned that an opt-out model is not the most straightforward and transparent way for victims to make a choice at a traumatic time, and our amendment sets up a framework that supports a clear choice and recognises that victims may change their mind over time. An opt-out model, on the other hand, means that victims' personal data is shared unless they request otherwise, which could have unintended consequences if they do not realise they have to make such a request or are not in the right frame of mind to make the choice at that time, and increases the risk of data being shared without genuine consent. It also does not distinguish for vulnerability or for child victims. And the caution that is required around understanding of what the process involves and capacity to make the choice to opt out. Police Scotland copies me into a letter to the Criminal Justice Committee which raises concerns about the automatic data sharing aspect of Ms Chapman's amendment and sets out the significant barriers to Police Scotland operationalising it. This reflects the Scottish Government's own assessment of some of the risks posed by Amendment 103, as I have already set out. Presiding Officer, I will also take this opportunity to inform the Chamber that Police Scotland has already begun a programme of work in conjunction with victim support organisations to ensure victims are referred to support agencies. This has included improved guidance and operational briefings for officers, changes to IT systems to make it easier to do retrospective referrals and a refreshed care card for victims following the People at Heart approach to communication, which was informed by people with lived experience. Presiding Officer, I ask Ms Chapman with respect not to press her amendment and urge all to support my amendment, which delivers our objective of providing a stronger referral pathway for all victims and provides a person-centred approach.
Thank you. I call Maggie Chapman to speak to Amendment 103 and the other amendment in the group. Ms Chapman.
Thank you, Presiding Officer. As this is my first substantive contribution to this afternoon's debate, I want to thank the Cabinet Secretary and all of her officials for their discussions about this bill and my amendments over many, many months. I also refer colleagues to my register of interests. Prior to my election, I worked for a rape crisis centre. I'm indebted to organisations that provide support and advice to victims and survivors of some of the worst crimes imaginable. I have really valued the conversations and discussions I've been able to have with these organisations and survivors themselves about elements of this bill. One such area is that on awareness and availability of support services for victims and survivors. I know from my previous work experience and from listening to survivors that awareness of the full range of support services available to them is nowhere near as high as it should be. Information is not easy to find, and practices of referring to such support services by police officers and others is inconsistent at best, non-existent at worst. Indeed, according to Victim Support Scotland, referrals have dropped by 90% over the last 8 years. We cannot accept that. Victim Support Scotland and others have long campaigned for an automatic referral system unless the victim or survivor does not wish to be referred. That is what my amendment addresses, as Jamie Green sought to do at stage 2. All victims must have easy access to the support they need when they need it to recover and move on from the crime committed against them. Now, I do accept that Amendment 84 goes some way to address this issue, but I do not believe it goes far enough. My amendment would ensure that there was always a follow-up, always that next question, allowing the victim the opportunity to consider the range of support options that should be open to them. However, I do accept that Police Scotland has raised concerns about this amendment, specifically that the data sharing required could present challenges given UK data protection legislation. So while I won't press this amendment, I urge the Cabinet Secretary and Police Scotland to be very clear of the need to improve the ways in which referrals happen, to ensure victim survivors have access to the support they need and deserve when and where they need it. And I am grateful to have had the opportunity to raise this issue again, because we must do better. Victim survivors deserve nothing less. Thank you.
Thank you. Call Jamie Green.
Thank you. I'm speaking in this Group 11 as I've added my name in support of Amendment 84, which has been brought by the Cabinet Secretary to the Chamber. It very much echoes an amendment I brought at stage 2, but agreed not to move and to work with the Government on. I understand the reasons why this is in the Cabinet Secretary's name and not my own, because first of all, there have been so many technical conversations around the sharing of data, which underlie quite a lot of these changes, which perhaps are concepts which, when the original acts, the 2014 Victim Witnesses Act, for example, came into play, issues such as GDPR were very different in their technicality. But this is needed, an amendment of this nature. I actually was very sympathetic to the amendment in Maggie Chapman's name. I understand the pushback around the data sharing issue, but actually, as it happens, my interpretation of it was interesting, because I read the amendment as it is stated in black and white, that the police, as soon as is reasonably practicable, after someone has been identified or appears to be a victim, that they are referred to a victim support service unless that person intimates that they do not wish to be referred. Of course, that opt-out, that agency always exists, so no one's information would ever have been passed without their consent. So in that case, I would have supported it. But I do understand that Police Scotland have pushed back on that issue. It also, I think, raises the question of what do you mean by a referral? Is in the black and white of legislation, does a referral mean that that person's data is taken by a third party and passed on to somebody else? Or is a referral simply the signposting of a victim to a third-party organisation, in which case there are no data issues? And I don't think that's entirely clear from the amendments. I think the latter, of course, being easier because it doesn't fall into those GDPR issues. So I understand the reasons that 103 hasn't been pushed. I certainly won't push it, but I hope that members will support 84 as a compromise. But I think overall it's simply a first step in the right direction, that not just Police Scotland but all justice partners need to be far more proactive in signposting victims to both support and notification schemes. And any changes that happen in future, and I do hope there will be changes to both of those processes, that all justice partners know that they have a duty to signpost people to those wonderful organisations that we all know and can make such a difference in helping people navigate through the justice system. So I encourage members to support 84 as well.
Thank you. I invite the Cabinet Secretary to wind up. Anything further to that?
Presiding Officer, just to briefly respond to Ms Chapman and Mr Green, that there is of course a clear need to improve referrals, and I believe that Amendment 84 will be part of the solution to this. I also have to acknowledge the point made very powerfully by Ms Chapman that referrals have fallen by 90% in comparison to pre-GDPR level of referrals. GDPR is the law. We can't ignore that. We have to respect that and operate within the bounds of that. But that has to increase our resolve to find those other solutions in a systemic approach, so that the system is far more proactive in supporting victims to exercise their rights.
Thank you. The question is that Amendment 84 be agreed to. Are we all agreed? Parliament is agreed. I call Amendment 103 in the name of Maggie Chapman, already debated with Amendment 84. Maggie Chapman, to move or not move? That amendment is not moved. I call Amendment 85 in the name of Jamie Green, already debated with Amendment 66. Jamie Green, to move or not move?
To move.
Question is that Amendment 85 be agreed to. Are we all agreed? Parliament's not agreed. There will be a division, and members should cast their votes now. And the vote is now closed. Okay, the result of the vote on Amendment 85 in the name of Jamie Green is yes 54, no 59. There were no abstentions. The amendment is therefore not agreed. Parliament will now be briefly suspended for 15 minutes to allow for a comfort break. I'd be grateful if members could be back in their seats by 5:15. Thank you.